Good afternoon, everyone. I'm Carrie Shuffler. I'm the director of the Law Related Education Program at the Idaho Law Foundation. This is our second training session, and this topic is an introduction to how to try your case. We have two presenters today, and I will let them introduce themselves. Both have been mock trial coaches in the past. First, we have Greg Dickinson, who was an attorney coach, and he's also the chair of our Law Related Education Committee. And we have Chris Schlecht, who was a teacher coach for many years at Logos, and so has a lot of experience, and both of them together will have a lot of really great information to share with you. So I will pass this over to them and let them introduce themselves. Why don't we start with you, Greg?
Thank you. As Carrie said, I'm Greg Dickinson. I've been involved in mock trial for a long time, and Chris and I were both coaches of the Logos mock trial team for a number of years together. I was the attorney coach while he was the teacher coach. And then I retired from coaching just to do mock trial stuff at the state level, and he continued on for a number of years. Chris, anything you want to add to that? You're muted.
I am muted. Yes, my Zoom was yelling at me that I'm muted. Yes. Yeah. If you're here, it's probably because you're already sold on mock trial. But yes, I was really privileged to coach some teams that did fairly well, and I was able to see the educational value of it for a lot of kids. I coached for 24 years. Some teams that went on to nationals, and I really think this is one of the best things going for high school kids. And I say that both as a dad, seeing it for my own children, and also for the kids that I've taught. So anyway, welcome.
I'm going to I'll get started. I'll upload the outline so that anybody who watches this can take it with them. What we're going to talk about today is putting the case together with your team. You will have this year's case by now, and this year's case is a criminal case. So there's a couple differences between the two, although in mock trial they're not quite as noticeable. In a criminal case, the plaintiff is always going to be the state or the government, trying to prove that the defendant committed whatever crime the defendant is accused of committing. And in a criminal case, the burden of proof is always on the plaintiff to prove the guilt of the defendant beyond a reasonable doubt. And there's more detail about what that means in the jury instructions in the case. What that means is practically that the defendant doesn't have to provide any evidence about anything. In a real case, the defendant could be absolutely quiet, not say anything, not ask a single question, not introduce any evidence at all. Obviously, in mock trial, that's not the case. The defendant does testify, and the defense will offer evidence, but still the mindset is not that the defense has to prove that the defendant didn't do it, or that somebody else did, or that something else happened. The defense just has to raise reasonable doubt in the mock trial case. And so as you go through the case and analyze, you're keeping that in mind. You're not, from the plaintiff, the prosecution side, you're looking at, okay, what are the facts that will prove the defendant guilty beyond a reasonable doubt? The defense is looking at what reasonable doubt can I throw into the case, or it exists in the facts of the case, to undermine the prosecution's attempt to create reasonable doubt. Chris, anything you want to add to that?
No, I think that summarizes it well. Greg, one thing that you alluded to is the jury instructions, and you're probably going to head to this, but what I would always tell my teams is that the jury instructions are the most important part of the case materials. They become the window through which you examine everything else. And usually the burden of proof itself that you identified is laid out in the jury instructions. And then the elements that must be proven are there. So with the mock trial case, you have pages upon pages upon pages of stuff. Well, look at all this stuff through the lenses of the jury instructions. That's what all, which includes the burden of proof that Greg was alluding to.
I uploaded the outline that we're covering today to the chat. So if you go in there, you'll be able to find that and download that. So I won't go over a civil case at this point because it's in the outline and this year is not a civil case. But once you've identified the kind of case it is and figured out burdens of proof and things like that, then it's time to develop the theory of the case. And the theory of the case is basically the story that you're trying to tell. And each side will have a theory of the case. The prosecution will have a theory of the case, a story that the prosecution wants to tell about what happened. And the defense will also have a theory of the case, although theirs are going to look different because of the different burdens of proof involved. Some general considerations for the theory of the case. You want to account for as many of the facts as possible. And part of that is deciding which facts are important and which facts are not important. There's all sorts of things packed into a mock trial case that are red herrings. They don't really matter. They're just there to give you something to sort through or to create an interesting evidence problem. But you have to decide what facts are important, what facts are not important, and weave those into the theory of the case. You don't want to let the theory of the case change or invent any facts. In any mock trial case, you wish you had more facts than you do. That's the way the case is written. There are holes in it in order to, well, partly in order to prevent one side from being clearly the winning side. But that's one of the reasons that we have the unfair extrapolation theory, is because you always wish you had facts that you don't have. And you can't let the theory of the case make up any facts. You can't let the theory of the case change any of the facts of the witness statements. The facts are the facts, and you're stuck with those. Your theory has to be a plausible theory. That's pretty self-explanatory, but you want to, it's probably more tempting with the defense to try and come up with some theory that's, a little bit out there. But again, you want your case to be believable. You're going to be presenting this to judges and members of a jury, and your case has to be believable as you present it. Chris, anything you want to add? Feel free to jump in anytime there is something you want to.
Yeah, well, Greg, and of course, I think that was well said. But in terms of defining what is and what is not important, Greg said that there are some things in the cases that are red herrings. What is a red herring versus something that's relevant? And here I'm going to return like a broken record to the jury instructions. The jury instructions are your guide as to what matters, what is important. And when you're presented with case materials, the jury instructions are the portion of the case that both sides have agreed upon is the law that applies. And so a judge will instruct the jury, and the jury has to make a decision. And the jury instruction lays out the criterion by which the jury has to decide, is this defendant guilty or not? Or is this plaintiff liable or not? Or whatever. That's the jury's decision. And the jury instructions then lay out what is important for the jury, what decisions they're going to have to make. And so it could be that there are little nuggets or phrases or little details in the case that might have a greater bearing on that jury's decision than some things that take up a lot of column space, a lot of text in the case. Just because something occupies pages and pages in the text doesn't mean that its weight is important as maybe certain little lines or phrases in the case. And the jury instructions help you to make those determinations.
That's a great point. Always you will never go wrong by going to the jury instructions. In the current case, they start on page 55. And just to give you an example, and this is common to many, many cases, but instruction number 6 in this case, the third element says that the state has to prove beyond reasonable doubt that Kingsley Ford knowingly sold computer chips manufactured by Tater Chips. Well, that means that the prosecution has to come up with all the facts that indicate that Kingsley Ford knew what was going on. And as you can guess, there's nothing obvious in there where Kingsley's going to say, I knew exactly what I was doing. So that's going to be all sorts of circumstantial evidence rather than direct evidence, which will be discussed in another one of these presentations. But you've got to present all the facts that indicate that Kingsley knew what was going on. And then the defense likewise is going to show all the facts that cast reasonable doubt on the fact or on whether or not Kingsley Ford knew what was going on. So in this case, instruction number 6 is your guide in coming up with the theory of the case.
Right. Yeah, that makes then pages 56 and 57 the most important pages in the case materials.
That's, yes, in a criminal case, that's exactly right. Those will be your guide.
I will have to say though, as one of the main people who wrote this case, I'd like to think that there's other important pages in there too, but that's neither here nor there.
Yeah.
Okay, if the case is artfully crafted, the case is brilliant, everything is important, but then some things are more important than others.
Just in terms of the compass you're going to use to get through the case. And so that's a very good way to develop the theory of the case. As you read through it and as you read through it with your students, have that jury instruction with the elements of the case right in front of you, and so that as you go through the case, they can be looking for those facts that support each of the elements of the case. And some elements are going to be more important, not more important, but more obvious than others. For example, I was just about to say on or between February 2021 and May 2022. Usually nobody disputes those kinds of things, but in this case, there might be some reasonable doubt about the timeline. In the state of Idaho, that's probably not going to be in dispute. But you want to look for the facts that support each element of the case. Don't take anything for granted. So steps to developing the theory of the case. And Chris, I want to make sure I give you some time here too on this to go through your, I don't know if you have your spreadsheet, but you showed that to me the other day.
Hey, Greg, just real quick.
Really yes.
Before we move on to the nitty gritty of that, I just want to stop for a second and see if any of the participants have any questions for us. You can raise your hand,
sure.
or you can just go off mute and ask your question, or you can type something in the chat. I'll wait for a second just to make sure that everybody's caught up. All right, go ahead.
Okay. So we've talked a little bit about this, but there are steps that you can follow to develop your theory of the case. One of those, again, reviewing the elements of the crime, looking for the facts that will either prove or disprove an element or raise reasonable doubt about each element. And then you also you don't want to just think about your own theory of the case. You want to be able to understand what the other side's theory of the case is going to be so that you can contend with that. You want to, for example, if you are the prosecution and you are going to present some fact that you believe makes it more likely than not that, or establishes beyond a reasonable doubt, I should say, that Kingsley Ford knew what was going on. Well, defense, you need to know what that fact is. You need to know that fact exists, and you need to know how you're going to respond to it. And that's part of developing your own theory of the case. Sorry, am I still here? My computer screen just flashed on me. Okay, great. Part of developing your theory of the case is understanding the other side's theory of the case, knowing what facts they're going to bring up, knowing what objections you're going to raise if they ask certain questions or try and bring in certain evidence, knowing how you're going to respond to that evidence if it does come in. Chris, anything you want to throw in about that?
No, I think that's well said. I'm happy to kind of walk through that chart that offers maybe kind of a step-by-step and systematic way of laying out, I think, what you're suggesting. So go ahead and cue me, and I'm happy to take that up.
Okay, yeah, let me get through a couple of these the rest of the points,
Right.
And then you can illustrate it with your spreadsheet.
Right.
As you're deciding what to do about and again, you need to anticipate not only the other side's case so that you can respond to that, but you need to anticipate the other side's response to your own case. If you're trying to get in something that might be hearsay, you need to know how you're going to present that evidence so that it can get in. And there'll be a whole nother one of these about evidence. So I'm not going to go into that right now. But again, the point is you need to understand what objections you can raise to the other side's case and what objections they're going to raise to your case, how you're going to respond to that. You need to know what your weaknesses are. You need to know where the weaknesses are in your case. You need to know where the weaknesses are in your opponent's case. And then you need to be able to account for those. You need to know what the law is as well. And again, in these cases, the law is presented in the jury instructions, so you'll know what that is. It's in the rules of evidence, it's in the rules of procedure, but you need to know what that is and how to apply it to your case as well. And then usually in a case, there are things that are going to be critical issues that you really want to make sure you emphasize and that you get in and that you establish from as many directions as you can. And again, in this case, I'm not trying to give anything away because honestly, I don't know how this case is going to develop. I didn't write it. I wasn't part of the discussions behind it. But knowledge appears to be a key element in this case. And so you're going to want to do everything you can to make sure that if you're the prosecution, that you can establish Kingsley's knowledge. And if you're the defense, make it clear that or raise reasonable doubt with regard to Kingsley's knowledge. Chris, so the spreadsheet we've been talking about, Chris showed this to me the other day. It's a spreadsheet that he used in developing the theory of the case with Logos, and it's one way to keep organized as you go through it.
Right. So first of all, by way of preface, I'm going to show you a spreadsheet it's a Google form, and the link to it is up in chat. But if you will follow along with me, so you don't need to click onto the link. I'm sharing my screen now. Can you all, let's see, can you all see that?
Yes.
All right, very good. So this is just a simple spreadsheet that I created, and my plan is to give you a tour of the spreadsheet. It's a tool that helps me as the coach and helps the students that we're working with to develop a theory of the case in a systematic way, and it incorporates the principles that Greg has been discussing. So first of all, you notice down at the lower left, I've got the prosecution case, and I'll click on the tab defense. You know, they changed very slightly. I've got one for prosecution, one for the defense. Basically two different sheets, one for each side. And what I have on the left-hand column, the element to prove, if you look on the jury instructions, this is what Greg and I have been jumping up and down on with the jury instructions. You'll notice I've numbered them 6.1, 6.2. This is jury instruction 6 at points 1 and 2 and 3. And I just copied those right onto the left-hand column. If you're the prosecution, you need to prove that the events occurred at the time on or between February 21 and May 22. Secondly, in the state of Idaho. And then 6.3, that's the element of knowledge that Greg was describing. And then you'll notice that I took element 4, because element 4 has a logical operation in it. I divided that into 2 separate rows on my spreadsheet. Either the defendant knowing the computer chips were stolen by another, or 6.4b, or the defendant should have known. Basically, that's what that means. Such circumstances, it would reasonably induce the defendant to believe the property was stolen. So, and then 6.5, the property was in fact stolen. So if, to put this in terms of reverse engineering, if the prosecution fails to prove one of these elements, any one of these elements beyond reasonable doubt, the prosecution will fail in its duty. The defense can prevail by preventing the prosecution from proving one of these elements, by raising doubt that's reasonable doubt with regard to any single one of these elements. All right. Now, what I've listed across the top are the names of each of the witnesses. Now, as you make your way through the case, we've got, and I have them there by first initial, last name. So we have the prosecution witnesses, Adams, Moltisanti, and Pentito. And then the defensive witnesses, Ford, Magnum, and Vera. What is that, Dr. Aloe Vera? Shout out to the case writer's creativity on these names. But you see, I've got all 6 of the witnesses there. Now, what I encourage the students to do then is, as they read through the witness statement of Adams, then take note of anything that has a date stamp on it, and that can go to this point on the spreadsheet. So we're reading Adams's witness statement. If there's anything that's timestamp bound, then I'll put it here on the cell. Anything that identifies that it's a state of Idaho, I'll put it there, and on and on and on. So what this does is it gives the student a set of lenses for reading through Adam's witness statement. And then we do the same thing for the other witnesses, Moltisanti and Pentito. What I do with students after we're presented with a case is we gather everyone in the room, and I put this up on a big whiteboard, and then the students meet in, groups, pairs or groups of 3. And, one little group will work on the Adams statement, and another group will work on the Moltisanti statement, and so on. And then the students will go up on the whiteboard and basically fill out the chart. And then I have the students actually maintain a Google Doc that they circulate with one another, and we actually develop this document as we're developing the theory of the case. So each of the witness statements tells an individual story, but remember that the important things in each witness's story are the things that bear upon the jury instructions, right? So this helps me to notice or recognize the jury instruction related material in each witness statement.
Hey, Chris.
Yeah.
Could I ask a quick question on this here?
Yes.
When you're going through these witness statements, are you just trying to find the stuff that makes your side of the case, or are you also going to make note of the things that could be used against you in that, or do you do that on the other side? Do you understand what I'm asking?
Right. Yes, great question. Notice, first of all, that's a great question, and I'll answer it sort of indirectly. The answer is yes, we of course want to see both sides of this, as Greg said. So we begin with the prosecution side. You'll notice that on the prosecution side, we're actually going to go through even the defense witnesses and find things that are good for the prosecution side. So everything in this chart is going to walk through all 6 witnesses and things that are favoring the prosecution. Then when we go to the defense side, and so I just clicked to the other tab, you probably can't recognize that I did that. But notice these are, I've got 2 sheets here. There's a prosecution sheet and a defense sheet. And so these are, each sheet is sort of, it's an advocacy sheet for your respective side, but you need to fill out both sheets. And there, in any witness statement, there can be some things that advantage one side or the other. Sometimes, and this is often the case, there might be some things in prosecution witnesses that actually are not good for the prosecution side, that actually advantage the defense side. And so I would put that on the second sheet then. But you notice you've got all 6 witnesses for both sides. So we're analyzing all 6 witnesses through 2 points of view, of advocacy, advocating for the prosecution or advocating for the defense. What this allows us to do then, basically it results in really 12 columns. 12 columns when you take the 2 sheets together. We go through each witness statement twice, one time from each perspective. So Carrie, does that get at your question?
Yes, thank you. I appreciate that.
Yeah. Now, what we can then use for this sheet, the next step for this document then is that it becomes the basis upon which we construct the examinations for each of the witnesses. So the things that, for example, if I'm the prosecution and I'm calling Adams to the stand, I'm probably not going to have every row on the chart filled out through Adams. Hopefully through all 3 of my witnesses, each row in the chart will have been covered. But that guides me as to what I need to highlight in the examination for my first witness, Adams, and then for my second witness, Moltisanti. And then it also guides me into what I want to extract in cross-examination from the opposing witnesses. And then when we turn, I'm clicking onto the next sheet, the defense side, then notice that this then will be the defense's cross-examination of Adams, cross-examination of Moltisanti, and then the direct examination of Ford, Magnum, and Vera. Now there's also, I also need to talk about exhibits and how to handle the exhibits, but before we do that, I want to make sure what I've said is clear thus far.
Does anybody have any questions?
Nope.
All right. Okay, there's one further wrinkle now, having walked through this, what I call it, it's like an analytical tool. It's a way, I mean, here you're presented with 80 pages of stuff. How do you wrap your brain around 80 pages of stuff, and how do you help a 10th grader wrap his or her brain around 80 pages of stuff? And this is at least the best tool that I've been able to develop to help the kids do that. Now, we also, in our case materials, we have exhibits. As we make our way through the case materials, we discover that some of the witnesses are going to be familiar with the contents of some of the exhibits. And so now I haven't read this case thoroughly here, but if you'll notice, I've got this row here for exhibits. Back to the prosecution side. Let's say Adams is familiar with exhibits 1, 3, and 4. Then I would write here exhibits 1, 3, and 4, because this witness might be is equipped to deal with those exhibits as well. And so that would also, the material for exhibits 1, 3, and 4 would go under this column. And the second witness might be equipped to deal with some of the exhibits too. And so I would likewise put material from those exhibits under the columns for the witnesses to which the exhibits are relevant. So as you navigate through the case, studying both the witness statements and exhibits, figure out which witnesses are equipped to deal with which exhibits, and then you put the materials from the exhibits under the same columns that pertain to their respective witnesses.
Hey, Chris, could I ask just a clarifying question with that? What is the process you go through with the students to help them determine which exhibits can go with which witness? And then how do you take it to the next step of the how? How are you going to build that exhibit into the case?
Yes. What that is, and that's usually a later step, but it's a necessary step. It has to do with, it's basically seeking to marry a witness statement with the exhibits. You read through a given witness statement and you read through all the exhibits, and then you ask yourself, you know, for exhibit 1, for exhibit 2, for exhibit 3, and all the rest, you know, which of these can Adams testify to? Which of these, then I'll ask the same question for all the exhibits. What are there, 6 exhibits in this case, or 7? Yeah. Then for exhibits 1 through 6, which of these can Multisanti testify to? Oftentimes the witness himself or herself will make reference to an exhibit within the body of the witness statement. And so that's my cue. Oh, if Multisanti, for example, makes explicit reference to the material in exhibit 2, then I would put exhibit 2, I would list that under Multisanti. And you notice that oftentimes these exhibits will appear in more than one witness. So if we've got 6 exhibits, we're probably going to find all 6 exhibits appearing under several different columns.
Can I jump in there for a sec?
Yeah.
I think this will get covered more in the session on evidence as to what all this means. But what you're looking for is, the legal way to put it is, who has knowledge of the exhibit, who can authenticate the exhibit firsthand. So, for example, if you look at exhibit 3, the loan reference letter that Dr. Auden Vera signed there. Well, the questions you ask are, all right, well, who can testify about this letter? Well, Janet Trasker could testify what? That she received the letter. Well, we don't have Janet Trasker as a witness. Who wrote the letter? Well, Dr. Auden Vera did. We do have Dr. Auden Vera as a witness. So perhaps, without stating anything too obvious, Dr. Vera could testify about the letter. I don't recall whether or not Kingsley says that Kingsley saw the letter, but if Kingsley saw the letter and has firsthand knowledge of it, there's another potential witness that could get the exhibit in. So you're looking for somebody with knowledge of it, and as Chris said, sometimes it's more than one witness that could testify about the exhibit.
Right. So what I would do, following up on what Greg said, so that was exhibit, what, 3, you said?
Yes.
So you see, I just put the number 3 under Auden Vera, which is my cue that when preparing the examination, either direct examination or cross-examination of Auden Vera, I would be looking to Auden Vera's witness statement as well as exhibit 3 for material that I would use to populate this column. So.
And then just a quick follow-up question. I know that when teams use exhibits, they don't use every single exhibit. So what's your process for then deciding which exhibits you will incorporate for your case and which ones you won't?
Yeah, do you want to take that, Greg? Or
Yeah, that goes back to what matters to the theory of the case, what's important, what's not important.
I pulled that down. Would you like me to put it back up again?
Yeah, if you want to put up
All
yeah,
right.
sure.
Okay.
Yeah,
I
you can
didn't know
take
if you all
exhibit
wanted to-
3 again. Oh, go ahead.
I just wasn't sure if you wanted to look at my pretty face or if you wanted to look at
Either one is a delight.
there we go.
But if you take exhibit 3 again, you have to ask questions. And again, what's your theory of the case? How does this exhibit either prove one of the elements I need to prove or cast reasonable doubt on the case? And that's how you're going to decide, well, what am I going to do with this exhibit? Am I going to bother to bring it in? If an exhibit is there but really doesn't matter to your case one way or the other, then you might leave it alone. And I'm not suggesting this about any particular exhibit in this case, but you want to ask yourself, does it prove one of the elements or tend to prove one of the elements beyond a reasonable doubt? Is the exhibit useful for that? Does it cast reasonable doubt on the case? Do I want to use it for that purpose? And so that it's just like any fact, when you're deciding what exhibits to bring in, you look at them like any other fact within a witness statement. Is this a fact that I need to establish in order to prove my case or cast reasonable doubt on the case if I'm the defense? And you'll find too that some exhibits are pretty straightforward. Like again, exhibit 3, reference letter, speaks for itself. Other exhibits you might find that they are by themselves don't do much, but they're a dot that needs to be connected either to other testimony, or they are a dot that connects two witnesses' testimonies together, or they go with another exhibit to connect dots together. So again, in this case, there's a trail to follow, and you have to ask yourself, well, is this exhibit important in establishing that trail? And then bringing it in at the appropriate time and making sure that it's used to connect the dots. Again, I'm not trying to suggest, I haven't seen most of the exhibits, so I'm not trying to suggest anything in particular, but that's how you need to look at these things. If you look at exhibit 5, a sales summary, well, what am I going to do with that? Is that something I need by itself? Do I need a piece of that? So I need to get in the whole exhibit in order to emphasize one piece of it. Do I need to bring that in with something else in order to establish an element or cast reasonable doubt on the case? And you might have both sides using the same exhibit for completely different things. For example, exhibit 5 or exhibit 4, you might have one side saying, well, look, this exhibit shows this, and the other side saying, yes, but this exhibit also shows this, and therefore there's reasonable doubt. So you might have one exhibit that has 2 purposes depending on which direction you're coming from.
Right. And if I could circle back to in my broken record self, the guide for ascertaining all of that comes back to the jury instructions. Does it relate to, is there something in an exhibit that makes one of these elements more or less likely? And the more probative an exhibit is toward establishing or undermining one of these elements, the more important that exhibit will become in presenting the case. So when my baseball analogy, when I tell my team, keep your eye on the ball, the jury instructions are the ball. The jury instructions are the ball. And so if there's something in an exhibit, and it's the same rule for witness statements themselves, there might be paragraphs that really don't appear in a substantive way in the presentation of the trial, but then there might be these different lines that are that are very important, then you're going to focus and develop those. Same goes for the exhibits. In that exhibit 5 that Greg highlighted, that is kind of the ledger, probably, I would imagine in exhibit 5, some of these lines and some bits of information are more important than other bits of information. How do I decide the importance? Well, does it help me to establish one of the elements in the jury instructions, or does it help undermine one of those elements in the jury instructions? And once again, for orientation, as I look at exhibit 5 here, this is something that was gathered by lead investigator Adrian Multisanti. So if I go to my chart, Multisanti exhibit 5 is going to appear right there on my chart, because Multisanti is capable of addressing the material in exhibit 5.
Well, this is a lot of really helpful information. I've got a couple other questions, but I wanted to toss it out to the folks, the other folks in attendance, to see if there's anything they'd like to ask. Okay, I have two other questions. One is, in our coach's manual, in addition to theory, we also talk about theme. And I wonder how you tie that to all of this, just briefly. I mean, there's information about that in the handbook, but if you could kind of talk about how you address that, that would be lovely.
Sorry, what was that?
She asked about how to develop a theme. Yeah,
that's a great question.
When I think of case theory, then I think of this spreadsheet. Really, it's the analysis of the case, but I have to make this analysis. This analysis has to make sense in a storytelling way to a jury. And so a theme is, I would propose, it's the artful presentation of it. I remember, Greg, this was a case you and I worked on. This dates us back to 2008. It was one of my favorite themes, where the theme was family and security. Members of the jury, this case is all about family and security. Of course, that was not this case, that was a different case, but boiling it all down, you want the jury to keep these story elements in mind that will help communicate the analysis that you're walking through. And so that's what a theme is. It's sort of the rhetorical sculpting of the analysis.
Yeah, and you'll when you put together your opening statement and your closing argument, that's where you'll present that kind of thing, your tagline, if you will, or your elevator pitch about your thesis, your theme of the case. You will want to build a structure in your opening so that as you go through the case, the jury can fit the facts and the elements that you're putting together into that structure. And then at the end, during the closing argument, the attorney is going to stand up and say, we told you this case was about thus and such, and here's how we've established that. And that provides that framework. And again, the theme is you build it by going through the case, deciding what's important, what's not, what's the story. And a lot of that will develop itself as you go through the witness statements. You might, one of the witnesses might stand out and say, well, I want to tell it from this witness's perspective or in this way, or some combination thereof. But as Chris said, you're telling a story.
Mm-hmm. Yeah, that's really the delightful challenge here, and it points to what I think is the educational value of mock trial. We've already seen we have analysis from different, even opposing points of view, which is such an important life skill, analyzing the same facts from different angles, different points of view, but then the packaging of those facts to make it compelling in a human way, in a storytelling way. And that's when theory matures into theme.
Thank you. That was very helpful. And then my last question is just from a kind of a broad sense, how do you approach the case? I mean, you have your tool for outlining the case, but from the time that the case drops and you get it to the time that you go to your first round of competition, you know, do you have the students read it in advance, or do you read it together? You know, how do you use the case as your guidepost throughout your season?
Yeah,
Read it.
that's right. And the kids on my team, sometimes they're, you know, you would ask them, so do you memorize the case? Most of them would answer, I think, give an answer like this: memorization, that is so shallow. We are so far beyond memorization. But Carrie, I think you're asking like the teacher's question, just mechanically, what's the process? You know, so you've dumped the Idaho Law Foundation dumps 80 pages into our laps. What do you do? And so I have the team read it independently. It becomes assigned reading. You know, give them a span of several days to read it, and then we'll gather for a practice. The expectation is that they will read it. And then at that first practice, we have a discussion about the jury instructions. And then we develop this chart in that first practice. And then in the first practice, it was my, you know, the first time I've got the team gathering post once the case is published. The first thing we do is I just divide them into groups. Okay, you know, group one, you've got the Adams statement. Group two, you've got the Moltisanti statement, and so on. And then we start filling out the chart. And once again, we use the big whiteboards in the classroom, and the groups kind of develop it on their own. And then each group writes down their column on the, you know, on the chart. And then that creates a conversation. Then we'll ask, okay, if you're the prosecution, what's the most important thing in the Adams statement? If you're the prosecution, what are the most important things in the Moltisanti statement? And we just walk through each one, and you've got traction then for several practices thereafter. These conversations that we have going witness by witness. It's also been my practice because the prosecution, or in a civil case, because the plaintiff bears the burden of proof, we usually spend some time, and it usually occupies a few weeks just on the prosecution side after the initial vetting of the case, really trying to strengthen and beef up the prosecution side before we turn to the defense side. And the reason why I begin with the prosecution and spend a few weeks on that before turning to the defense is because the defense's job is to introduce reasonable doubt. Well, reasonable doubt about what? Reasonable doubt needs to have some sort of direction. It needs to have a subject that's getting doubted. And so that's why we start with the prosecution. You know, what is the prosecution really trying to prove? How can it do that? And then that gives us some idea about what we're trying to cast doubt on the other side of the case.
I'll add to that especially for attorneys, it's important to take lots of notes in the case itself. Highlight, margin notes, underline things. If you run across something in one witness statement that relates to an exhibit, then you write the exhibit number in the margin. Just lots of things like that, so that you're building basically a trial notebook as you go, so that you know not just the thing you're looking at on that page, but how it relates to the rest of the case. And notes within the case itself are a great way to do that.
Well, thank you to both of you for being here today. And I'll just ask one more time, does anybody have any additional questions?
No questions, but great material.
Thank you.
Excellent.
Yeah,
Excellent.
I will say that Google Doc, you see the link there, and I'll just invite you. You can click on it And you can use the same Google Doc, just plug in different elements of a case for other cases. Make your own copy of it and have at it.
Would you-
I downloaded it and I will send it out. to
Okay.
you. So.
Fantastic. Thank you.
Yeah. Okay, well, thank you all for being here today. I appreciate your time, and our next session is next Wednesday, and it's about it's a mock trial law school led by Judge Lorello.